Samantha, our hearts are with you. It seems like you're going through the most difficult time. I'll explain the facts to yourself, Nick and Bruno, and as well as to our viewers. But essentially, she says, my lounge and kitchen ceiling have collapsed on my children. And this was at the end of November 2021. She says this was as the result of severe floods and hail in Johannesburg, which cracked roof tiles on the home that she's renting. She says, we immediately notified my landlord with photographs of the damage, and no help was provided to clean up the debris from this damage. She says, we eventually had repairmen come over to the house 2 months later, and to date, the repairs have still not been completed. She says that she doesn't have working kitchen lights. I think there's still damage to the ceiling. She says she's exposed to moldy rafters, and there were live wires that were exposed, and she, in fact, herself has been shocked. She says that I then received confirmation from the body corporate that the insurance does not cover my damages. My landlord, in this case, admits that the house is not in his name. It's still in the previous owner's name, and that they do not have homeowners insurance, so the damages cannot be claimed for. She says, the use of my stove and sink is limited. The wooden framework is falling apart. To date, we're still waiting and can't afford to repair this on our own. She says, yet we still have to pay our full rental, and we can't enjoy the property to its fullest extent. She wants to please be advised or some assistance in this regard. Nick, how can we provide assistance to Samantha here, or what advice can we give her?
So there's a lot to unpack in the particular question. And unfortunately, this is one of those questions that really depends on the facts. There's a lot of different things in there. I think where to start is just the fundamentals of a lease agreement and things that people need to remember. So one of the things that stood out there was she said that her particular landlord of this property is not the owner of the property. Now, it's important to remember that you do not need to be the owner of a particular property in law to lease it out. Okay, you can not be the owner and still have a lease agreement in respect to that particular premises. You, as the landlord, even if you aren't the owner, still owe certain duties to your tenant in terms of that lease agreement. Okay, and the primary one is obviously the use and enjoyment of the premises. You need to provide your tenant with undisturbed use and enjoyment of that premises. So there's a lot to unpack with regards to the damages, and it would take a lot of looking into to see exactly how those damages were caused. Our listener is talking about damage which potentially originated from a tile roof inside a body corporate, which is obviously going to fall under body corporate responsibilities. But that leaked somehow onto the internal roofs, and that might then become a liability for the particular landlord in the circumstance. So there's really a big assessment that has to go in on where did the damage originate, who has responsibility in the circumstances. And unfortunately, from a position where we're just sitting having a chat, those things can't necessarily be determined with any accuracy. However, what is important for our listener to remember is that if your use and enjoyment of the premises has been reduced, okay, or detracted in some way, then the landlord is not performing in terms of the lease agreement in the circumstances. And there are a couple of things that need to happen. Even if your lease agreement doesn't deal with these particular circumstances, there is a potential for you to argue for remission of rental as a result of you not being able to use and enjoy the property to the full extent, or depending on how bad the damages are, there might be a potential argument for the cancellation of the lease agreement in its entirety. As to the damages, which it seems that there were just damages to one's personal property that were situated inside the premises that got damaged as a result of the water. The ultimate liability there is going to have to take a more in-depth assessment, as far as I'm concerned, as to where those damages originated from and whose responsibility it was at the end of the day. Determining whether it was the roofing or the ceiling within the particular house and what happened there. Bruno, I'm not sure if you agree.
No, absolutely. No, 100%. Unfortunately, there's so many different components and facets to the question. It's virtually impossible to touch on each. Exactly what you said. I mean, we had conversations last week about sectional schemes and how a damage to one part of the scheme, what does that mean? Who's responsible to fix it? Does the landlord have recourse against the owner, et cetera, et cetera? So that's impossible. So from a damages perspective and quantification, and responsibility to fix. So if you want to stay on the property, the landlord needs to take steps to make sure that whatever insurance covers whatever damage is actually accessed, because he's the only one that can submit claims to either his own insurance for household, which sometimes cover tenant belongings, to the structure insurance, to the body corporate insurance, but he would have to move along with that. The remission and cancellation for me is key here, because there's no point staying on this property, potentially getting more damage to assets. So I'd say that a lot of the stuff can probably be dealt with outside. So maybe it's time to argue that the lease needs to be cancelled. You need to move somewhere else, quantify your damages, lay a claim, and let him worry about fixing the roof and the tiles and whatever else.
Yeah, I sort of just wanted to also ask a question there in terms of what we're talking about, the remission and cancellation. And just with regard to the fact that, let's say in this particular case, Samantha decides that she's going to stay and continue to stay on the property, but by virtue thereof, her property, being her belongings in the house, gets damaged. And now she further damage is done to the property, and now she's trying to claim for those damages. Is there a responsibility on the tenant in this particular case to ensure that the damage that has occurred actually stops at a point in time? So you move certain things, let's say, away from a leaky area, from mold and so forth. And does the landlord in that case have a claim to say, well, you've allowed this to happen? Or in fact, when the leak of the ceiling happened and came down, you didn't move it away immediately. Those damages are then on you. Is that the case? I think I'd like to pose that to the both of you.
So I think it's an important thing that everyone should remember. As a standard rule of law within South Africa, every person that's suffering a damage has a duty to mitigate the damages that they are suffering. That is a standard provision in South African law. So if you are in a situation where you are incurring a damage, you cannot just let the damages accumulate in the circumstances and expect that the law is going to come to your rescue. It simply isn't. And there's absolutely an argument that the landlord would be able to make to say you had a duty to mitigate your damages. So you should have moved your items from the leak so that they didn't get damaged more. Absolutely, the landlord's going to have that ability. That doesn't, however, detract from the fact, and as Bruno says, that the landlord still has a responsibility to do the same thing. So the landlord has an obligation and a duty to ensure that no further damage is incurred, as does the tenants in the circumstances. And that's really a balancing act. And that's why we approach courts in circumstances, because the argument is going to be from both sides. Well, who did what they were supposed to in the circumstances, and who ultimately bears the responsibility for those damages?
Absolutely.
Thanks, Nick. Thanks, Bruno.